Hello, my name's Antony Sassi. I'm a partner in RBC's Hong Kong office, and the issue I want to discuss today is collective redress and class action regimes. The reason I want to talk about this is that it's no longer just an issue that is restricted to the US. We've seen large settlements in other jurisdictions this year, in particular in respect of storm finance in Australia, which settled for $30 million US, and more recently the Fortis class action settle in the Netherlands. Regardless of your view as to whether or not collective redress and class action regimes are a good or a bad thing, they undoubtedly change the litigation landscape dramatically, and with that, the overall exposure. For that reason, it's an important issue for our clients, and particularly our insurance clients. In Asia, the lead in respect of class actions has been taken by Australia, who have had an effective class action regime in place for many years now. So you're starting to see very large class actions and settlements in that market. And it's now become, outside of the US, the most litigious environment in the world. Given its proximity to Asia, it tends to have an influence on the various jurisdictions in Asia. So the question is, what are we seeing in those jurisdictions? In Korea, they've had a class action regime since 2005, which has been limited to securities class actions. There have been proposals to broaden that, but they haven't really gone anywhere. More recently, in Thailand, at the end of last year, we saw the introduction of a class action regime through the Civil Procedure Code. And already we're starting to see class actions in that jurisdiction. In particular, in May 2016, there was a class action by a group of villagers around the Chartree gold mine against Akara Resources in respect of environmental damage caused. And that's quite telling to see the developments and how quickly class actions are starting to take place in that jurisdiction. In Hong Kong itself, class action regimes really gained momentum since 2008, following the GFC and the Lehman mini-bond crisis. In 2012, the Law Reform Commission made proposals for a class action regime, which essentially was modelled on an opt-out principle. However, I think it will be some time before the Hong Kong legal market has an effective class action regime, because the current proposals don't seek to tackle the issue of funding. In Hong Kong, we still have a loser pays principle like they do in England, and contingency fees are still illegal. Until the issue of financing is tackled, I think it will be some time before we see an effective class action regime operating in Hong Kong. Because even if you make it easier for people to group together and pursue litigation, the question remains as to who's going to pay for it.